morning, everyone, and a very warm welcome to Radcliffe Chambers, and a very warm welcome to the discussion that Sophia and I will be having this morning. This morning, we're going to be discussing remote execution of wills using video technology following the change to the law this week, and some ideas about how to avoid any pitfalls and some best practice ideas, particularly for ensuring that should anyone try and challenge the will at a later date, relying upon the fact that this rather unusual form of execution had been used, we've got good arguments to push back against any challenge. And then we're going to look at forged wills, and in particular, probably I think the most recent decision on forged wills, which is Sophia's case of the estate of Dean Brunt, which is a fascinating case. And I think when you hear the facts, you'll probably feel as I do that Sophia was robbed. But I'll leave her to develop that in a moment. So it was approximately 2 months ago, on the 25th of July of this year, that the government started to try and reassure people that anybody that had used video technology as part of a will execution process wouldn't find themselves with an invalid will, and that the government would take steps to ensure that it would be valid and that this legislation would be retrospective. Now, presumably the government must have heard that people had started to deploy video technology in the early days of the lockdown that came with the COVID-19 epidemic. Although I've not myself heard of anybody trying to use this technology to begin with, but I'm sure there must have been some urgent and some extreme cases. And the government promised to use the Electronic Communications Act 2000 to amend the Wills Act to allow what the government referred to at the time as a virtual presence by video link. Now, virtual presence is a bit of an oxymoron, but it was pretty clear what the government had in mind. And true to its word, although it hasn't used that term, a virtual presence by video link, in the legislation, it has amended the legislation and it's made it retrospective, and it came in just a couple of days ago this week. And it did it by the Wills Act 1837, Electronic Communications Amendment Coronavirus Order 2020-952. And if we can bring that slide up, Sophia, if you wouldn't mind. Sure. This, you'll see what that order did to Section 9. Now, the original Section 9 now becomes subsection 1, and that's the section that we're all very familiar with and the one that we've been dealing with for a very long time. And I've highlighted sections C and D because they're the only two parts that the amendment affects. And again, we're very familiar with that. That's the requirement that if we're going to make a valid will, the testator's got to be in the presence of the two attesting witnesses present together at the same time. He or she makes the will. And those attesting witnesses, when they sign and attest, they'll need to be in the presence of the testator, but not necessarily each other. We all know that. And obviously, it's presence that's caused difficulties with the epidemic. Most wills are either executed in people's homes with neighbours popping round, or in your offices when you finally got your gross will ready and people pop in if they're in town, or they make an appointment to come and see you and everyone sits together in the conference room. Maybe colleagues come in from another part of the office to attest and so forth. That's obviously, even for people who are not unwell or people at increased risk, is difficult, and there's restrictions on travel and so forth. So with those problems with presence, the government then introduced by the amendment subsection 2. And this says, for the purposes of paragraphs C and D of subsection 1, in relation to wills made on or after the 31st of January 2020, which I think was reckoned to be one of the dates of one of the first diagnoses of COVID-19 in the UK, and on or before the 31st of January 2022, presence includes presence by means of video conference or other visual transmission. Now, we've seen this week increasing numbers of infections, so it's quite likely that people may have to start, if not using remote witnessing, certainly having to consider it for some cases. Now, as you'd expect, the previous understanding, the previous jurisprudence on what amounted to presence remains completely unchanged. You can see that the extension is just to include video conferencing, video transmission. So the analysis and the understanding of what physical presence meant all still applies and all holds good. And to, I would say, very broad terms, video conference and visual transmission are not defined terms in the Act. And to the best of my knowledge, they're not defined terms generally. They're not defined in any relevant legislation or case that would enable us to sort of give some interpretation to what's been said in subsection 2. So Video conferencing is pretty obvious. That's the facilities that we're all now quite experienced in using, Skype for Business, court hearings, Zoom and so forth. What visual transmission adds is not entirely clear, but I would imagine somebody using a mobile phone and perhaps FaceTime or WhatsApp might not constitute a conference, but would certainly be valid for this. But for fans of TikTok and Snapchat, this is probably not the occasion to deploy either of those two. And one of them, I can't remember which one it is, Sophia. Isn't there one where you watch it and then it deletes immediately after you watched it? So you can imagine if that was a piece of evidence for a trial, you'd have it, you'd go play it once, and the court staff would say, we set it up and given it one run through for you, that would be the end of it. So let's just have a look then. What's the existing position in terms of presence? Because of course it wasn't necessarily just about physical presence, and sometimes physical presence wouldn't necessarily be enough. And we know that the authorities started to develop this idea of visual presence, or a clear line of sight, combined with a conscious understanding of what's going on. And I've highlighted just two cases that you probably have seen before, Brown and Skerritt and Kuza, that developed what the court had in mind for presence before we started looking at these sorts of situations that we're in now. Now, Brown and Skerritt was a case where the testator went into a shop and she went up to one counter where Miss Jeffries was. The testator signed her will, executed her will. It was witnessed by Miss Jeffries. And at this time, the other shopkeeper, Mr. Reed, only feet away at another counter, but he had his back to the action and he was dealing with a commercial traveller. And Miss Reed went over to his counter, asked him to swap over. He went over to the testator. She said, "This is my will," and he signed it. The theory attested it. And that was rejected by the court. It's quite a short judgment, but it's a nice, concise one, and it's pretty straightforward. And the essential reason is you can't really be a witness of something that you're not conscious of, which is, I think, pretty obvious. And what the judge said was that Mr. Reed had no opportunity to see and had no idea of what was going on. And I have to say, some of the early video conferences that I've done, it was pretty obvious they didn't have any idea what was going on. And the central point from the judge was you cannot be the witness of an act that you're unconscious of. Now, if you go to Kuza and Kuza, and this is a decision of His Honour Judge Collier, and I think Judge Collier takes what I would say is quite an insouciant approach to what's required for the proper execution of a will and presence. And he seemed to me to be quite influenced by the morality of the case, which he actually commented on. That's the case where the testator had already signed his will. And he went to his friends, Mr. and Mrs. Bovingdon. They had a small holding and a bungalow on small holding. Mr. Bovingdon was out feeding the livestock. The testator went in with Mrs. Bovingdon into the bungalow and acknowledged his signature. And she was there and she then saw it signed. But of course, Mr. Bovingdon wasn't present with her at the same time. Then he came in, and then they were both in this open plan part of the bungalow, and the signature was acknowledged to him, and he then signed the will. And at this time, Mrs. Bovingdon wasn't there at the dining room table with them. She was off making coffee. And interestingly enough, she was saying that she thought the whole thing was invalid, and she advised the testator to go to the bank. And ironically, the evidence of her saying, "I think this is being done incorrectly and is invalid," was used to prove the validity of the will, because the judge said, well, clearly she knew that the will was still being executed, that the deceased was acknowledging his signature, and everybody knew what was going on. And what the judge said in his decision was, that's Miss Bovingdon, she could see, if she had chosen to look around, and I find it almost inconceivable to think that out of the corner of her eye during the coffee making, she saw nothing of what went on. Now, just pausing there, that idea of people catching things out of the corner of their eye is a pretty risky strategy at the best of times, but it's certainly not the sort of approach that we think should be adopted if one's deploying remote witnessing. And then the judge said the situation is wholly different from the two shopkeepers in Brown and Skerritt, and she, that's Mrs. Bovingdon, I find duly acknowledged her signature. She was witness to an act that she was conscious of, so picking up on the decision of Skerritt and Brown. Now, the way the judge approached this was to treat the whole process as one sort of composite transaction. So he said, well, the testator acknowledging signature in front of Mrs. Bovingdon, and then Mr. Bovingdon coming in, the dialogue and the conversation between the three of them about the will being maintained, her being present making coffee when the husband did the attestation. That was all one transaction. And to try and break it down into the testator acknowledging his signature in the presence of two witnesses then carefully attesting and signing the will, was not the way to go. And he described that. He said that such an approach would introduce a ridiculous and fatuous degree of artificiality into a very speedy and everyday minor transaction. I don't agree with that, but what I would say is two things. When you look at the sort of best practice guidance that the government has promulgated and that Sophia and I have discussed in our notes that we'll look at in a moment, we don't advocate a ridiculous and fatuous approach, but I think we do advocate a certain degree of artificiality. And I would say that if one's going to be using remote will making, that you want a very demonstrative process, not an ostentatious process. And when we look in a little while at the best practice, we do contemplate a rather artificial situation where people are declaring what they're going to do out loud and then doing it. And this is all being recorded. And this seems to us as the very best way to avoid possible challenges later on. And I think that the learned judge's comment that will making is a very speedy and everyday minor transaction suggests, first of all, that he probably doesn't sit on too many contentious probate cases, but it's certainly not the way to approach remote witnessing, and not to allow this idea of one composite transaction where people are sort of toing and froing to be satisfactory. It wouldn't be. I think it would be far too risky. So before we look at the best practice, I'm sure many of you know that there was a bit of a debate about whether or not Section 9 in its unamended format was sufficient to allow remote witnessing anyway through video links. And I've read articles and I've heard people discuss this, building on the line of sight cases and building on other decisions, and saying, well, actually, you could do it without amending Section 9. Well, that debate's fallen away because the section's been amended, save for one possibility. As we said at the beginning when we looked at Section 9, subsection 2 only amends C and D, and that's, thanks for it. So that's only the signature made by the testator or the acknowledgement and then the attesting witnesses. Crucially, subsection 2 doesn't change at all, subsection 9(1)(a), and that's where the will is signed by the testator or by some other person in his presence and by his direction. And I think any argument that somehow that original wording would be okay for somebody to be remote when the testator is directing that they sign, that be in their presence, would be a risk simply not worth taking. And now that the amendment has deliberately excluded subsection 9(1)(a), I think the argument completely goes out of the window. As I was saying to Sophia, the reasoning of the article that I read was based on a case called Hudson and Parker. And in Hudson and Parker, what the judge was talking about was, he said, well, you've got to have mental presence as well as physical presence. It wasn't saying you can have mental presence instead of physical presence. And of course, Hudson and Parker was dealing with a case that took place at the time that photography was in its infancy. So I don't think it's got much to tell us about how safe it would be to rely upon video conferencing for Section 9(1)(a).
So am I right?
So
really, is it, sorry to cut you off.
No, do go on.
So really, it's not completely remote execution of a will, is it? It can't be completely remote, because whilst the witnesses can be remote, if you're signing at the direction of the deceased, like a deathbed will, you have to still have physical presence.
Yeah, absolutely. Yes, you're right. So the opportunity was there, presumably, to go for full remote execution. But when you think, of course, Section 9 is a section to prevent fraud. So I think that the forerunner to Section 9 of the 1837 Wills Act, and one of them was statute of frauds to begin with. So it's a fraud prevention technique, and it's a measure to prevent that. And presumably the idea, and you can think like in practice how the scope for fraud, for undue influence, even for mistake and confusion, if you start to allow that key thing to be done remotely and to have full remote execution, would probably just be too great a risk. And perhaps the need is not there. So as you say, there isn't fully remote execution of will because of that requirement still being there, Section 9(1)(a). So it's a good point. So can we then go through, Sophia, to the slides on our ideas of best practice? Now, what I sort of suggested there, I think the first one, they're almost sort of in order of importance, because they start off with last resort and planning. Now, we had an interesting question submitted by a gentleman called Tim from Thomas Barton, I think it is. So hello, Tim, if you're out there. We can't see you, I'm afraid, if you are. And Tim says, it's a good point, is remote witnessing of wills going to be the go-to challenge, the go-to route for challenge if you can't get knowledge and approval off the ground or something else? I think the answer is it probably could be, say for this. It is a last resort, and if it's confined to those cases where it's truly necessary, then it probably won't provide that much scope for challenge. And so what we think is that actually this decision about whether it's a last resort is a first sort of important step, where you have to then sit down. I say that not in the physical present sense, but sit down perhaps on the phone with the client, and to just consider every other option. What are the other options in terms of socially distance execution? Building on the line of sight cases, using a conference room with an interior window with a perspex screen, dragging people out into the garden, just remembering all the time clear line of sight and a conscious understanding of what's happening, and actually to sort of create an attendance note about that. So that if in the future, if you do go down the remote video transmission route, and in the future somebody tries to perhaps opportunistically exploit that rather unusual route, you can say, well, look, a very good piece of evidence to begin with to push back against that is to say, well, we considered every other opportunity, and this was truly the last resort, and that's the only reason why it was used. Now, interestingly, I think clients should probably be told pretty early on, if they want to deploy this, it's not easy, it's going to be time consuming, it's going to take some planning and some execution, and therefore it's not going to be an inexpensive way to go. I think clients in this day and age, for a significant number of wills, not perhaps highly complex instruments that come off after a lot of estate planning, but for a significant number of people with even some quite sizable estates, they expect wills now to be a fairly inexpensive exercise in their preparation and execution. And people are used to, as I say, popping in over their lunch break and signing the will in your offices. This is not going to be like that. This is going to take planning and a little bit of strategy. So that's our sort of A and B. Make sure that it is a last resort. You can't do it in any other way. And the old cases of the people retiring to their carriages and then the carriage being reversed up to the window. You can have a variation on that theme, and maybe we'll end up with drive-through wills. Just as I was speaking, I think there's our next business opportunity, a drive-through will window. But so you explore and rule out all those possibilities so that we are using remote witnessing as a genuine last resort. And then I think, getting sorted in advance with the client, where is this going to happen? Who's going to be where and when? Who are they going to be? Are people going to have identification with them? Wouldn't be a bad thing for witnesses if they're going to be in remote locations. Passport, photo ID, driving license, holding it up to the camera whilst they're giving their name and address, saying who they are. One's almost doing this with the expectation of a challenge, or trying to find out ways of perhaps heading a challenge off at the pass if one comes. Now, C, the identity of the attesting witnesses. Now, I understand there's probably lots of people watching this saying that we live in cloud cuckoo land as counsel, because we think that you've got a cast of brilliant possible attesting witnesses you can call upon, and very often you won't have. And we've had some, Sophia and I have done cases where you call the attesting witnesses hoping that they're going to change the case because they're probably the most important witnesses. And sometimes you wonder, why was this person picked? And I was telling Sophia yesterday my favourite example, which is a trial where we called the attesting witness, and the first thing is to just get them to confirm their witness statement so it can stand as their evidence in chief in court. And when he was taken to his witness statement and asked if it was his statement and he made it, he said no, he'd never seen it before in his life. So it was an inauspicious start, but actually things improved and the will was actually admitted in that case. So I say there, the bumbling but well-meaning neighbour might not be a good choice. If you're going to have three-way video conferencing, having people who feel comfortable with using video conferencing, and that's not everybody at the moment still. We've had to learn fast as lawyers because of the way the court service has operated. But it's choosing people that can take it in their stride and not really phased, particularly if there's a problem. Things go wrong, they just need to sort of calmly get things set up again. Obviously, the clear line of sight. Discussing this with Sophia, I was thinking that one of the things that would be quite nice to do with the testator, if the testator is in a room and you're having to supervise this remotely yourselves, is if you could have a camera angle that showed, for example, that the testator was alone in that room while you were communicating with the testator, checking that they were happy with everything, checking that they had read through the will a final time, understood it, knew what was in there, approved of it, that there wasn't, a big nephew leaning over them, helping them out. And if you do that, of course, then there's a danger that somebody might be sat there at a distance and signing, and somebody saying, well, is he signing the will? We're not sure that that's his signature. So you might need to change the camera angle partway through, but you might need to just ensure that, again, the testator holds it up and says, this is my will. I've just read through it, and I'm now about to sign my will here, and make sure that that signing can be seen. And that's what we say at E, just make sure that it can be seen, rather than, again, it's not to say that if you simply see the testator sign the document at the table, that it'll be insufficient. It's rather, if you can show now that it is the will that you've just held up to the camera, that you are now at the table signing, you're closing down all of the confusion. And sometimes when people challenge wills, of course, as lawyers, we never do this, but you muddy the waters with as much confusion and deviation from standard practice as possible. And then when I said we were talking about Judge Collier's observations about an artificiality of his fatuous process in Cusa and Cusa, well, if Judge Collier would think the process is overly artificial and fatuous, then I think you're on the right track. Because what I suggested there is that the witnesses ought to say aloud what they're doing. I think there's no harm in people saying, it's Joe Bloggs, I'm at this address, here's my identity. On the 15th, I saw, so-and-so execute their will. That will's now been posted to me, or the courier's brought it round, I've got it here now, this is the same document, and so on. And to just talk through what they're doing. And the government has suggested some wording, which I got at G, which is something for their testator to record, which is that they are making a will by their own free volition, or free will, as they say there. Too many wills, I think. Free volition would be better wording. And they're signing it remotely before witnesses, and so on. H and I, they're just the points that you already know from section 9 and physical presence, that both witnesses have got to be present at the same time on the broadcast with the testator, and then each of them, if not both of them together, have got to be with the testator when they're doing their attesting and witnessing. Now, the amendments don't make...
I was going to ask you a question.
Go on, yeah, come on.
It is quite an involved process then, isn't it? Because you're going to need at least 2, maybe 3 different video conferences. Because you have the testator with all the witnesses at the first time saying, this is my will and I'm signing it. And then if they can't be together, the will's going to have to travel. Perhaps
That's right.
2 more times to then have 2 more telecons or video calls that the testator's also in. So it's not easy, is it?
It's not easy. I mean, that's part of the planning. I think that's why we say our second best practice point after make sure this is a last resort, is planning. Because you might want to think about if the estate warrants it, if the money's there and the clients are going for it, you might say, well, okay, well, if we're going to have these 3 people on this day, and you're going to be in Greenwich, and you're going to be in Reading, you're going to be in Maidenhead, well, why don't we, if you're available all day, book a motorbike courier and just do it, just have it taken round and do it in that way. Now, not every estate would warrant that, and sometimes the clients might say first class stamp will be fine, but I try and push them towards recorded delivery. But you're right. I mean, that's why I think the planning phase is probably quite important, because there's a bit of a logistics, and of course that's what we're just going to sort of come on to in a moment, because there's a risk of delay there. Now, most of us have seen cases and even dealt with cases where people try and launch negligence actions based on the fact that the will wasn't done fast enough, and the testator dies inconveniently during the course of the process. Well, this route will give testators new opportunities to die before it's all finished, because it might be, if there's time before you can get people online, particularly if you can't have the attestation and the attesting witnesses together at the same time, that has to be done by separate conferences. And you've got to, you're relying on a family member to drive the will about. And want to think about, who are you going to rely upon driving the will about? Is there a danger of somebody picking the staple out and putting another page in and all the rest of it? So the integrity, the security and the integrity of the document is something to think about too while it's traveling around, because all the old risks are still there, they're just heightened. So thanks for that. What I was going to say was that Jay, is that the amendments could have made it clear that some form of pre-recording is a non-starter, but they don't. But I think the use of the terms video conferencing and video transmission show that you are definitely dealing with a live broadcast like the one that we're on now, and not pre-recording a testator doing something and then having attesting witnesses watching that pre-recording, however tempting that may be. And it could simplify the process, but would lead, I'm virtually absolutely certain, to invalidity. As I said there, it's just sort of what we discussed. Because of the sort of problems that arise that we'll see when we look at Sophia's case in a moment, the government hasn't permitted the use of counterparts. The idea of, for example, we're used to in other transactions, perhaps real property transactions, where one contract is signed by one party and the other contract you have exchanged, and you may not necessarily in all cases end up with one document that has everybody's signature on it. And you can have valid transactional steps taken by the exchange of documents and counterparts. That's, again, a non-starter. It has to be the one actual physical document. And again, going back to that idea of artificiality, audio, I suggested it's worth keeping up a narrative, as I know, I am this person, this is what I'm doing, and this is what I've just seen, or I saw last Tuesday this happened, and now I'm going to attest. Apart from the fact it will help, I think, to prevent challenges, it's also quite useful to see whether your link or your video conference has dropped out. I mean, I've done hearings where the judge has such a stony expression on their face all the way through that you wouldn't know necessarily if it's frozen. And I've done hearing, well, it did freeze. But then it sort of jutted into life again. And I didn't realise, because I thought, well, he's just sat there looking miserable and has done for the past 2 hours. So if you've got an audio track going, it helps that you can spot, I think, a little bit more clearly whether everybody is on board, listening, watching, conscious, witnessing an act that they're conscious of, to go back to the authorities that we looked at. And so an audio dialogue helps to check that everyone's still connected, everyone's still listening and knows what's going on. So that's, well, there's a couple more. What have we said there? Oh, the attestation clause. It would be wise for the attestation clause to record that it's been done remotely. There isn't a particular required form of attestation by Section 9, there never was. But one that records the fact that it's been done remotely would be wise. And we make the point that it should also perhaps state whether or not, although you can't use pre-recording, that you actually record the live events. And so, again, the statute could have said that a recording shall be maintained and so on, words to that effect. It hasn't done, but seems to me pretty essential to, if you can, maintain a recording. I don't know whether it could be argued it would be a breach of duty for somebody not to, for a lawyer, not to have maintained, or to, I think you certainly need to advise on it, definitely. I think the duty to advise on the risks would certainly include the duty to advise on the desirability of having a recording. I say it's essential to have a recording. And then that also then brings into focus who's going to store that. So you could have, I don't know, perhaps a good quality hard drive. If it, I mean, again, there aren't probably not be that many, but if it starts to actually become prevalent, then a good quality hard drive kept in your strong room where you keep the paper wheels and offering that facility of secure storage of the recording and all the metadata that could be crucial, could be useful. But if it's going to be the clients, then let them know it's their responsibility to maintain that recording, and it may not be necessary to look at it again for years. And again, and you don't need us to tell you this, I'm sure, but again, it's that part of full attendance notes and just perhaps being more laboured, more detailed than one ordinarily would be with this speedy and everyday transaction, as Judge Collier says, and preparing those notes. And again, none of the old risks haven't gone away, and all of the other requirements are still there. The fact that the testator has to intend, the animus testandi, has to intend to give effect to his will, that's still there. Substantial requirements of knowledge and approval, capacity, they're all still there. So those usual checks that are more difficult, such as spending time with the testator alone before everybody else piles in and tries to persuade them otherwise, is more important. And I think the recording of it is even more important too. So there are our ideas of best practices there, aren't there? Is there anything else you think we could go into? Are there any questions? I should have said before, this is our bit of a discussion. It's a remote discussion, which is perhaps opposite. But if you have any questions, or even just things you want to say, there is a question and answer box. And feel free to just post your observations. And if we spot any questions, we'll do our best to answer them. But you can also just post your thoughts. If you disagree with everything I've just said in particular, post that. I quite enjoy seeing that. Is there anything else, Sophia, that we could discuss before we go on to...
I think recording, when you were just talking, it occurred to me that, well, it's much like with COVID generally. We've realised that we've had all this technology to do things remotely all this time and just haven't bothered doing it. And I was just thinking, actually, maybe getting into the habit of recording an execution in itself.
Oh, yes.
Could have been cases.
Yeah.
There's so many knowledge and approval claims that could have been resolved probably by having it recorded.
Yeah.
Although ironically, I think I have seen cases where we've always thought it was one of the suspicious circumstances that someone had recorded an execution.
Yes.
But maybe now that will turn out to be the norm.
Well, first of all, it troubles me to hear you say that, because I've got a case in trial in January of next year in which we have a slightly covert recording on a mobile phone taken from underneath a hospital blanket of a will being very duly executed, I would say, in hospital. So thanks for that. That's given me an extra way. But you're right. I think that it shouldn't become the default option. But you're right. We can all think of cases, I'm sure, particularly things like knowledge and approval, where if you just had a video of the whole transaction, particularly the one where the testator says, "Ha, he'll be really disappointed when you get the carriage clock," then that really helps. It doesn't probably have to be quite like that, but I think that idea of somebody just carefully taking time to read through or the will being explained to them, that can remain secure. Nobody ever needs to know about that. It only needs to be brought out if there's a challenge later on. So I think it's a good point, and maybe we need, but certainly where the testator says, "I anticipate there will be problems after I'm gone," that might be an idea to start thinking about. It could be deployed there, even if it's not necessary for the remote execution.
Yeah,
I'm just going to see if I can click on this Q&A question.
Oh.
So if I disappear, you'll know it's because I'm highlighting the risks of doing things remotely. Might the recording provide ammunition for a challenge? Yeah, well, this is unfortunately what Sophia's just said. Most of the time, expert psychiatrists are stuck with medical records, absolutely. Do you really want to allow them to go over a video of a doddery old testator? Oh, Josh. Oh, so thanks very much for that, Josh. That's
really, thanks, Josh. He's
really annoying because actually, God, that has happened. I'll let you know in January, because our little recording is designed to show it actually knew exactly what he was doing. Look, as you say, I mean, I think it's an exercise of judgment, isn't it? There'll be cases where there's a risk that you might be adding to the difficulties. But in the case I just referred to that's coming up in January, we are hoping that the experts have seen and that they've actually taken into account the fact that he was certainly recorded as having a certain degree of capacity. How probative that is, of course, that's going to be a matter for expert opinion. Natalie says, what about if there are language barriers? Can a translator be a family member of the testator or a professional one? Also, do they sign the will in their original language or the translated version? It's a very good question. I think with translators, again, there's no, other than complying as strictly as you can with Section 9 of the Wills Act, there would be no requirement to secure an independent translator. But again, I think it's probably a judgment call. Should you, an independent translator, I think,
I'd say,
if you anticipate, so I think if you anticipate problems, and particularly if it's a family and the family dynamic is such that there could well be challenges and problems, you may want to, again, it depends on how it's being, provided the testator understands it, provided the testator knows and approves it and accepts it, then it's probably okay. I mean, it's interesting to see whether somebody might say, well, that word was mistranslated to the testator. It doesn't, in fact, mean that. And I think it's probably then going to be a question of whether that actually goes to anything. It's unlikely to go to formal validity in the sense of have you properly complied with the Wills Act and with remote execution, but it might go towards substantial validity and perhaps, I would have thought, possibly knowledge and approval. But it's a very interesting question. I don't know. I don't think there's any requirement, certainly for formal validity, that you would have to have some independent translator, and that simply a mistranslation, or as often as I guess everyone that's done cases with translations will know, there's no generally one perfect translation into English, depending on the language. There's always subtlety and nuance. Whether or not that would invalidate the will, I think would have to be determined on a case-by-case basis. I might ignore Josh's next question. So should you audition to make sure if it will look okay? Is that a serious question? I don't know. Well, you raise, whether deliberately or inadvertently, Josh, you raise a serious point, I think, because it's planning. It's what Sophia and I are saying in our list. It's planning. And I think having a dry run-through of the technology may not be a bad thing. You can probably tell by how slick all this is, but we had a look at that and the idea of a rehearsal. Now, unless you've got anything else, Sophia, to say about that thing, I don't want to eat into your time for you to tell us all about Dean Brunt and the dreadful decision in that case. How difficult, what more do you need? You tell us, Sophia, what more do you need to prove that a will was forged?
Well, so in this case, the estate of Dean Brunt, is quite a good example actually of how the circumstances or the choices that you make about how you execute a will can lead to litigation and suspicion as to fraud. The cost decision as well that's up on the slide is quite interesting, because it also shows that those same decisions about the execution itself can have cost consequences for the estate. It also, I think, goes to show just how hard it is to challenge a will on the grounds of forgery, however many factors you think that you've got weighing in your favour. So what was it about? So Dean died only aged 35 on 8th of December 2007. He didn't have a wife, he didn't have a girlfriend, he didn't have children or any other dependents. He just left his mother and his brother, Marlene and Dale, who I represented, and a sister, Venetia, and Uncle Bob, who was Marlene's brother-in-law. Marlene's evidence was that she had no reason to think that Dean had left a will. No one had mentioned it to her, therefore she obtained letters of administration and administered the estate on intestacy in 2008. Over 10 years later, Uncle Bob issues a claim to propound a will dated 2nd of March 1999, revoke the letters of administration to Marlene and remove her as the executrix in the will. Marlene and Dale defended, and we challenged the will on the grounds of forgery, due execution, and knowledge and approval. And this case, you may have seen it in the press actually, the tabloids got hold of it mainly because of the colourful and peculiar aspects to it. But before I get onto those, I think you need to know a little bit of the family history for it all to come together. So here we go. Dean had a granddad, Arthur, who owned a farm. Every good probate claim starts with a farm, doesn't it?
Yeah.
So in this case, it's the farm. And he left that farm, amongst other, he had many other assets actually, but he left the farm in his will to his wife for life, and then the remainder to his son Barry and the grandchildren Dean, Dale and Venetia in 4 equal shares. When he died in 1990, there was a very long and complex dispute about his estate, whereby, and in fact I think it lasted just until, or shortly before Dean died in 2007, so massive dispute. And in the midst of that, in 2004, and this is an important year to remember, in 2004, an agreement is reached over the farm whereby Mary releases her interest, her life interest, and Barry sells his quarter share to the kids. So as of 2004, the grandchildren had a 1/3 share in the farm each. Fast forward to 2015, Dean's died back in 2008. And there's now a rift in the family between Uncle Bob and Venetia on the one hand and my clients on the other. And it consists of different types of disputes, but all centering around the farm. So Venetia and Dale run a partnership from Ettridge Farm, and they have a partnership dispute. Uncle Bob has a few different claims he intimates. Firstly, he lives in a log cabin on Ettridge Farm, and there's a dispute about that. He brings a claim for money against the grandchildren. He also intimates a proprietary estoppel claim over a converted barn on the property known as the Old Barn. These disputes rumble on. In 2018, a mediation is scheduled for the partnership dispute, and just days beforehand, a will is circulated, the 1999 will, said to be Dean's last will. Unsurprisingly, the mediation is unsuccessful, and the parties focus their attention on the will. So what did it say? It appointed Marlene executrix. It gave 20 grand to Marlene, Valerie and Bob. Interestingly, it provided that Dean's my 1/3 share of the freehold of Ettridge Farm go to Dale and Venetia, and my 1/3 share in the property, part of the freehold known as the Old Barn, go to Valerie and Uncle Bob. Well, remember though, he didn't get that interest. He didn't have a 1/3 share in all of these things in 1999. He only received that in 2004. So it looks already on the face of the will like Dean's purporting to give away an asset that he just didn't have until many years later. Residue to Dale and Venetia in equal shares. Another thing to note about the will is that it wasn't signed by Dean. It was signed at his direction pursuant to section 9A by a person called Howard Day. And there wasn't a regular attestation clause. It said signed by the said Howard John Day as enduring power of attorney for Dean Ashley James Brunt, dated November 1998 in his and our presence, and then by us in his. The witnesses were 2 associates of Howard. Howard ran a business called ASA, and John Thorpe was one of his employees. And Mick Keeble, the other witness to the will, was a long-term friend and client of ASA and Howard. There's 2 points to make about the attestation clause. Firstly, those watching probably already be aware that an attorney doesn't have power to just sign a will on behalf of the donor. And also an attestation clause, you covered this a little bit, Paul, is meant to reflect the fact that all parts of Section 9 of the Wills Act have been complied with. And this actually, in our submission, suggests the opposite, because you'll notice there's no mention of Dean at all. It says that Howard signs in the presence of the witnesses and then them in his. So there's no record of Howard being in the presence of the deceased or there having been involved whatsoever in the execution. So already you can guess some of our forgery grounds, that the will was peculiar on its face, but there were other factors too. So, for example, the old barn is mentioned in the will. A third share is given to Bob. In 1999, it was actually a dilapidated cart shed, and there's a fantastic picture of this property in 1999 when the will was said to have been made, like this tumble down. You drive past it, you know, and just think, oh, it's, you know, about to fall over type old cart shed. But of course, Bob's interested in this old barn because I think after Dean had died, renovations were done to it to convert it into a residential accommodation. So now it's a very nice converted barn. But at the time of the will, why would Dean have wanted to give this asset to anyone? I've mentioned the attestation clause. Dean's name was wrong on the very front page of the will, which my client said he would have realised that his middle name was wrong. Similarly, Marlene's farm was misspelt in the will. My client said he would have noticed that had he been involved in this. The date on the will was also in the same type font as the rest of the will. So those that draft wills will be familiar that usually you leave a space to write in manuscript the date of the will, because you don't really know for sure what date this is going to get executed on when you're drafting it. But obviously the person that drafted this will knew that they were going to be executing it on that day.
They knew they wanted it done.
Yeah. We also found that the explanation for why Dean had signed the will was implausible. They said, oh, well, Dean said he would worry that people might dispute the will if he signed it himself. So he thought Howard should sign it. And actually the opposite is the case, isn't it? Yeah. And finally, they were duplicate wills, we found out much later in the litigation. And I'll come on to that in a minute, but Master Teverson actually held that having duplicate wills, because they are so rare, was one of the factors that he took into account to consider whether it was a forgery or not as well. So don't do duplicate wills, and if you're going to do remote execution, definitely don't do duplicate wills. Yeah. So other factors. We looked at the people who were involved. I've mentioned Howard. In the judgment, Master Teverson says that Howard runs through this case like a stick of rock, and he does, because he is central to everything. He was a land consultant. He ran a firm called ASA. He wasn't legally qualified, but his firm offered their services to basically resolve their clients' problems, and that often involved writing letters on their behalf, like a solicitor's firm would in litigation, trying to attend mediations for them. And Howard, in this case, he's the person that was representing Bob and Venetia in respect of the family disputes, or at least assisting them with that. He's the person that produced the will. He said, oh, I found it in my barn, days before the mediation. He's the person that's said to have drafted the will, to have taken instructions for the will. They say that all of this happened in the space of 5 hours on one day, the instructions through to the execution. He was the one that sent Dean off to a solicitor to have it checked over, which again we find implausible, because why wouldn't a solicitor have noticed this weird attestation clause, etc. And the solicitor himself refused to give evidence in the trial. And then, of course, Howard signs it. Howard then goes on to conduct this set of litigation for Bob as well. So Bob was a litigant in person for most of the litigation, with the assistance of direct access counsel and Howard writing letters on his behalf, and preparing some of the witnesses' witness statements as well. So why are we so concerned about Howard? Well, he had previous convictions for fraud. He was sentenced to 3 years imprisonment. If you go on Westlaw, you can find civil judgments against him that I've recorded on the slide. He'd been found liable for knowing assistance and dishonest receipt by assisting one of his clients with another fraudulent scheme. I think Patton J described him as turning a blind eye to his client's dishonesty solely for whatever financial benefit he might obtain. He was known to have held himself out or let others believe that he was a solicitor when he wasn't. So generally you can feel that he's very much the villain of the piece.
A bit of a wrong un, you could say.
Yeah, he's a wrong un. It's basically the message that we were running.
Yeah, we get the message, yeah.
At trial. There was also similar fact evidence, actually. There's a couple of our witnesses aren't referred to at all in the judgment by the master, but one of them, a lady called Sally Newton, came forward and said, well, actually, I've got a very similar story about how I think Howard had been, when he was in prison, he'd started writing letters to her elderly mother or mother-in-law who owned another farm, and it sounds like wooed this lady and got out of prison, went to stay with her, and when elderly Rona Newton died, he produced some handwritten note, said to have been written by him, giving him some kind of interest in her estate. And litigation ensued. I think he was unsuccessful. And in the judgment, the master does refer to how I think Howard was eventually made bankrupt off of the back of a costs order in the Newton case. So all of this was similar fact evidence as well that we were looking at. As to corroborating documents, the suspicion continued. There was no contemporaneous or formal attendance note of the instructions for the will or documents you'd expect from an instructing solicitor. In particular, Howard produced his 1999 handwritten diary, and on the face of the page for the execution, the naked eye would think it was all just black biro ink, and towards the spine, but later down in a bit of a space on one of the lines, it just says, "and signed up will." And we sent this diary to both handwriting experts, and both of them came back agreeing that when they'd analysed the ink on the page, the ink for those few words was a different ink to the ink on the rest of the page or anywhere else in the diary. And they believed it had been signed at a different time to the rest of the page, but could not say when. So we obviously said, well, this is also suspicious, that we say not only has the will been forged in the sense that it's been made without Dean's involvement and probably after he died, but this diary entry obviously looks like it's been doctored as well. We also relied on that significant 10-year delay until the production of the will in the context of the family disputes, and the lack of explanation as to why Howard hadn't raised the fact Dean had made a will when he died and left it 10 years. The second original will that arose, and this is the bit that the tabloids enlightened upon because of the cat that ruined the case. Not quite, it wasn't all the cat's fault. Basically, Howard actually died during the proceedings. He and John Thorpe, actually one of the witnesses to the will, had died by the time the trial was heard. I think it was September 2009. Howard died and instructing solicitors came on board for Bob. And Howard's son, Jonathan, took a big box of papers from Howard's house or office and brought them to the instructing solicitor. And the disclosure deadline had well passed. We were kind of, I think it was a few days before the PTR that she discovered another original will because she'd put a big pile of these documents on her desk for shredding, and her cat knocked them all on the floor, so the story goes, and when she picked them all up off the floor, she felt the indentations on what she thought was a photocopy of the will, and she realised this is another original. And the strange thing about this is that all of the pleadings, the witness statements, only ever talked about one will, singular. Even Bob's statement of testamentary documents, Mick Keeble, the only live witness to the will, in his witness statement spoke about signing the will, singular. So this was just another suspicious circumstance, we said. And both experts were in our favour as well. So both said these wills were executed at the same time. They said on the first will, as a standalone document, there was strong evidence to support the proposition that Mr. Day didn't sign it in 1999, but at a later date. And that whilst the signature on the second will was slightly more fluent in the way it had been written, they said it was more likely than not that both were written at the same time. And that was just done at, with better fluency. I think Ellen Radley, our expert, also said that in her experience, generally if you do two signatures at the same time, the second one's going to be more fluent because you're warming up into it. And she found an example of that. So the experts had been given they were able to say all of this because they'd had about 25 samples of Howard's signature ranging from 1990 through to present day. And they thought his signature was much more similar on the first will to kind of around 2016, his signatures then. They then said it would be quite a coincidence for Mr. Day to have written the signature on the first will in 1999, and in an unusual style relative to his writing at that time, and in a manner which is not found until later dated signatures. They also discovered that the second page of the first disclosed will was on a different paper and being printed on a different printer. And this was interesting because we'd specifically asked in a request for further information about how the will was prepared and where it was printed, and we'd been told it was on one printer in Howard's office. So again, there's an inconsistency between...
How does the judge deal with that though? I mean, how does the judge deal with a piece of fairly solid probative evidence like that?
It's not, that bit isn't dealt with at all in the judgment.
Well, that's one way of dealing with it.
So it's missed out. I'll come on to what he found about this. But as if we needed any more factors, there are some more. So Dean himself, a lot of what I'm saying here, I'm having to kind of gallop through this. And of course, actually every point that we took was disputed. It was a highly disputed case on all of these facts. And so I'm not able to cover all of it in the time we have. But a lot of what I'm saying actually doesn't appear in the judgment. For example, Dean was a schizophrenic, he had learning disabilities, he had a low IQ, and his medical records were before the court. And there was evidence from both my clients, but also another witness, again, who's not mentioned in the judgment, called William, who all said that from their knowledge of Dean, his difficulties and his character, it was just so out of character, this idea of him having made a will. And we said that all of these things went to knowledge and approval as well. So this witness, William, said that he wasn't even sure Dean could read. He said that if Dean was having trouble reading the leaflets from his medication that he would take, he would give them to William to read for him because he struggled to understand things. There was evidence that he tended to abdicate responsibility when it came to reading or documents to other people. He wasn't an academic bloke. That was something that was agreed. And he was a labourer, really, working with the machinery on Etteridge Farm. When he did need legal documents produced, he tended to instruct solicitors to do it for him. And we said he had no reason to make a will. We then highlighted lots of the inconsistencies in the case, which really, I think, we felt there were even more inconsistencies by the time that we'd heard the live evidence. For example, the witnesses couldn't really agree on who had drafted the wills, or at least between the pleadings, it was sometimes suggested it was Howard, sometimes it was John Thorpe. I've mentioned the printing of the wills. There's differences between the witnesses as to who was present and at what times different things in the execution happened. So what happened? What did the judge think? Well, the trial was listed for 8 days, but we actually had to stop partway through because of lockdown. This was March this year. So the judge said, I'm going to, those witnesses that I haven't heard from, I will read their witness statements and take them into account. And we did written closing submissions. And he upheld the wills, much to our disappointment, and he removed Marlene as executrix. So what did he say? Well, firstly, interestingly, he actually reversed the burden of proof for forgery, and those watching will probably be aware that forgery is obviously a very serious allegation. It's usually, the burden is usually on the person that's alleging it. And of course, the more improbable the allegation you're making, the more cogent the evidence you need in order to prove on balance of probabilities the thing that you're alleging. But he said, given the length of time since Dean's death and the fact Dean didn't sign the will himself, he placed the evidential burden on Bob with regards to the forgery claim and proving due execution. He dismissed outright. Sorry?
So that would be to your advantage. Yeah.
So the burden was on Bob, and then he dismissed the peculiarities on the face of the will that I went through on that slide and said, well, I think they more go to knowledge and approval than they do forgery. I have to say, I think that's wrong. I think they're irrelevant, whether it's actually Dean's will or not. Would he have made all of these mistakes? With regards to this my third share issue, he kind of accepted as plausible an explanation given by Bob that, oh, well, the grandchildren would have said my third share of the farm at that time. and he said it's possible to read the gift in the will as being Dean saying, I give my third share of the share that we all have in Ettridge Farm. And then ultimately he accepted Mick's evidence, the one surviving witness to the will, and Jonathan's evidence. So Howard's son gave a witness statement saying, and in his evidence he said, oh, I was in and out of the room whilst it was happening. Interestingly, the master says that the evidence is so ambiguous that it's not necessarily clear all of the requirements of Section 9 were complied with, but from what the witnesses said, he infers that relevant things happened, such as it being done at Dean's direction. He finds that they were all around a kitchen table together and infers that the relevant Section 9 requirements were met. Finally, he found that Dean had told people he'd made a will. And it got worse for Marlene. Unfortunately, he found that Marlene had been told a long time ago about a will being made and chose to administer on the basis of intestacy and concealed the administration from those people that would have been interested under the will. What did he do about the expert evidence? Well, he rejected it. He said, I'm not persuaded by it. He said the fact that they used the phrase, it would be quite a coincidence, implied it was unlikely, but couldn't be ruled out that these were valid wills made in 1999. And one other
probabilities. So they had the burden of proving the will and almost rebutting forgery rather than you proving it's a forgery. And whichever way, whoever has the burden, the standard being on what's more probable than not. Surely this is stretching it a bit.
Well, I agree. Yeah. The other thing that's useful perhaps to take away from the judgment is to do with presumption of due execution and attestation clauses. So the presumption of due execution always applies where a will looks valid enough on its face, and having a good attestation clause just strengthens that presumption. But in this case, we argued successfully that if the attestation clause actually suggests there might be something wrong with the execution, then no presumption applies at all. So it's not just that the presumption is weaker, there's no presumption.
Okay.
But things looked up a bit on costs.
Before you get into costs, Sophia, I'm conscious that you've only got a few minutes. Can I just ask you something else about it? Because it just seems to me, I don't know what everybody else watching thinks, but I find it quite a surprising decision, let's put it that way. Now, your trial was truncated because of the epidemic. I don't know whether those witnesses were important witnesses or not, but this is a classic case of where a judge is having to evaluate a large body of evidence, including significant testamentary evidence, oral evidence. Now, older members will know that it used to be that masters were very much procedural judges. I remember Master Price, before he retired, was always quite keen on that. He was a procedural judge only. And anything of real substance, and a probate case based on forgery would always be adjourned off to a judge. I mean, no question about it, would be dealt with by a judge. But we know these days, increasingly when we do CMCs, that a lot of masters are keen to say, well, this should be tried by a mastership. You have that embarrassing conversation where you say, not really, no. Do you think it made any difference? Does it make a difference? Does the trial format, does the judge make a difference in a case like this?
I think there's pros and cons, whatever level of judge or whatever forum you're in. For example, I mean, Master Teverson himself is very familiar with contentious probate claims. Whereas if you get in front of a High Court judge, these days you could end up in front of someone in the Chancery Division that does have no background. You might be in front of an IP judge, and that might require a little bit more teaching and your opening and closing submissions about the law to bring them up to speed. But I think this case has really made me feel more strongly that if you're dealing with a case that's factually complicated, really factually disputed on nearly every basis, and there's going to be I think it's an organisational skill for a trial judge, to be able to weigh and balance a lot of disputed factual stuff to make findings. But
it's experience as well, isn't it, of witnesses and getting a sense of whether somebody is telling the truth or embellishing it a little bit or being thoroughly dishonest.
Yeah, and so I think if you're dealing with cases like that, it is a good idea to think about, where do we want this to be heard? What we want an experienced trial judge. Where are we most likely to find someone that's used to handling this kind of this kind of case? So yeah, that's something that
on costs, though.
I was very happy with this judgment on costs. So here's the cost judgment, and I think this is relevant to the remote execution stuff that we were talking about before. People will know that the general rule of regarding costs applies to probate claims, but the first exception is that if the testator himself has been the cause of the litigation, then costs can come out of the estate for everyone. Now, I think my opponent was kind of gleefully heading into our consequentials hearing, lining up all of his arguments as to why we should have to pay the costs, and probably on the indemnity basis. After all, we had made a very serious allegation of forgery unsuccessfully, and the master had found that Marlene had known there might be a will, and she had concealed the administration on intestacy from the rest of the family. However, Master Teverson said, or was persuaded that the defendants genuinely, he accepted that they genuinely did not believe in the validity of the will. So he said, basically Marlene genuinely didn't think this was a valid will, so she's not really the cause of the litigation. And he said it was Dean and the choices that were made about this execution, so Dean not signing it himself, was the real cause and made it inevitable. And I've got an extract. He says, in the highly unusual facts of the present case, the conduct of Howard Day should be treated as part of or an extension of the testator's conduct. The fact that the will was not signed by Dean but by Howard Day on his behalf was of itself bound to be a source of family argument and suspicion. Both Howard Day and Dean, through proceeding in this way, caused the litigation. Howard Day ought to have insisted that Dean sign his own will. He ought to have ensured that it was recorded on the face of the will that it was signed by him at Dean's direction. In my view, it is just in the highly unusual circumstances of this probate revocation claim that the defendant's costs, as well as those of the claimant, should come out of the estate. And I think this could pave the way for some arguments as well on costs when it comes to remote execution.
Well, because a lot of remote execution would be possibly, if not highly unusual, then certainly unusual circumstances.
Yeah, and also
the extension of what the testator has caused by deploying that process.
Yeah, and I think when you look at a lot of the cases about the first exception to the general rule as to costs, it's about how the testator kept their testamentary papers. Yeah. Whereas this is about choices that have been made, unnecessary choices that were made during the process of execution. So if it goes back to your first point about, your letter A, last resort, that if you've done something that's a bit unnecessary in a way that's more likely to have caused litigation, or is particularly suspiciously done, or there isn't a good enough record to it, that it's inevitable litigation will arise, then perhaps this judgment will be a bit of a guide as to how you might be able to apply the first exception.
Have a go. Yeah, absolutely.
Yeah.
Okay. Well, thank you very much, Phil. I didn't want to stop you if that's it, but I see that it's just after 12 o'clock. I just noticed there was one anonymous question which I didn't get to because I was focusing on Josh's semi-serious question. What date should the witnesses insert? But the best practice is for the testator to date the will and not for the attesting witnesses to date the will. And there's no requirement for them to do so. So I hope the anonymous person is still there. I'm sorry that I didn't catch that before we went on to Sophia's talk. Sophia, is there anything else?
I don't have anything else to say. I've had a nice moan about my probate case.
You got it. It's cathartic, isn't it? Hopefully. Yeah, there you go. It's one of those cases that will keep you awake at night. It does. Well, thank you very much, Sophia, and thank you very much to everybody that's joined us. It's been a real pleasure having you along, and I hope that we'll see you again soon, either remotely via video link or hopefully next year in person. And thank you very much.